the laws and comply with the judge's order, whether that judge's order is a grant of asylum or whether that judge's order is a removal. The vast majority of individuals who, even though they surpass the credible fear threshold upon apprehension and their initial screening by CIS, ultimately, many of them do not ever actually file for asylum. And even those that do file, I believe the approval rate is in the 20% range. I don't have that exact number in front of me, but I believe it's in the 20% range. So the vast majority of these people we're talking about are not people with successful asylum claims.
Certainly with the detention docket or the detained docket, in 40 days we process folks, get them out. That's pretty quick. And I agree with what I've heard from my colleagues earlier, that we've got to be able to have a process that moves that quickly for everybody by hiring judges, having the infrastructure in order to do it. But if I look at some of these costs associated with alternative programs as well, that based on the significant reduction in cost that the GAO has identified, that it would take 1,229 days of waiting for an adjudication in an alternative program before it was more expensive than the detained. Mr. Edlow, you mentioned the average is 752 days, so it seems alternative programs from just a cost-benefit analysis are significantly cheaper. But let's move the process along. That's not making that argument. I think we need to be moving this process along a lot quicker. But let me, in my remaining time, I just want to mention something that I think is very important, and that is what our top priority in all of this should be, and that's the welfare and care of children who are in this process. A host of medical organizations, including the American Academy of Pediatrics, the American College of Emergency Physicians, the American College of Physicians, the American Medical Association, the American Psychological Association, and on, to name a few, have all concluded that there's irreparable physical and mental harm done to children who are placed in detention. Even brief stays in detention, according to these folks, can lead to psychological trauma and lasting mental health risk. So my question to really the panel is, in proposing rollbacks to the Flores settlement agreement, has DHS reviewed the extensive literature discussing the long-term health consequences that detention will have on children? Mr. Albence, you want to start?
The regulation writing process was very extensive. I was not personally involved in a whole lot of that, so I can't speak to all of the things that were reviewed during the course of that process. What I can tell you is that the family residential centers are humane. What we are looking to do with that regulation is not change the standards which we currently maintain. The purpose of the regulation is not to change the standards that we have that are currently exist. The purpose of the regulation is to bring us into compliance with the Flores settlement agreement, which was contemplated by the court, and that is the purpose of the regulation.
How long is too long, do you think, to detain a child in a detention facility?
I'm certainly not qualified to answer that question, sir.
Has your agency looked into that and thought about it and reviewed the literature associated with that?
I don't know. I could find out and get back with you.
I'd appreciate that. Anyone else like to comment about the review of your organization as to the psychological impact on children who are detained? Mr. Perez?
Senator, I'm not aware that with respect to CBP's particular review of the findings in the report, but we could certainly get back to you on that. I would just echo my colleague's sentiment that with respect to CBP's disposition, when it is that we do encounter children, their health and well-being is first and foremost on our mind, even if it is in our short-term care. We not only comply with all the standards that we have imposed on ourselves and others have, but nevertheless go above and beyond. The frontline Border Patrol agents and CBP officers do absolutely everything we can to assure their well-being while in our custody.
Mr. Edlow?
Senator, thank you. The Department of Justice's role in this process is to enforce the laws that Congress have passed. Certainly, if Congress amends the law to take that into account, we will enforce those laws. But I can't speak specifically. I'm not able to speak specifically to the reports themselves.
Well, I would like to follow up, Mr. Chairman, with all of you to get a sense of what sort of analysis has been done by each of your agencies to take a look at this, and I'm going to propose for the record, if I may, Mr. Chairman, a letter here signed by, I think, over 1,200 professionals and healthcare officials who believe that any kind of detention, even short-term detention, can have significant impacts on children. Certainly, I would hope that this is something all of you would take a look at. And I think we've got to find out who exactly is even considering this as these proposals come forward. From the testimony I've heard today, it doesn't sound like anybody is giving any kind of comprehensive, thoughtful analysis of the situation. Thank you, Mr. Chairman.
Without objection, that will be entered in the record. And by the way, while you were talking about asylum claims that have been granted, I do have a chart which I'll enter in the record, and we have staff making a copy and distributing it. But just give you the 10-year averages. 25% of asylum claims were granted, 28.2% were denied, 30.8% other closure rates, and that is abandonment, not adjudicated, other or withdrawn, and then finally administrative closure rate 16%. And there are some trends involved in here too. The actual denial rate has actually spiked up in the last couple of years. So again, we'll take a look at this, but again, that's just asylum, and as Mr. Albence was talking about, is some people don't claim asylum and they get removed or get a removal order as well. So there's a lot of information, a lot of data, and that's what we're trying to do, is try and accumulate all of it so we can get the exact picture of what's pulling off. With that, it's Senator Langford.
Thank all of you for your work and for what you're continuing to do to keep our nation safe. We appreciate that very much. You are carrying out the law and what you've been asked to do, and there are a lot of families across the country that are incredibly grateful for the work that you do in that. Look, I'm going to get a couple of definitions here. The number has come up over 90,000 family apprehensions. Is that 90,000 individuals total, or is that 90,000 families, not families, but we don't know what the number is within that family? Let's do a clarification there.
Thank you, Senator. Actually, for this fiscal year, CBP apprehensions both at the ports of entry and between the ports of entry through August is now over 130,000 family units, and that is actual individuals that make up. So 130,000
individuals that came as a family unit coming through.
Yes, Senator.
Do we know how many actual families that is? So does that represent 75,000 families or groups of individuals, or you just have a number that's broken of 130,000?
It's more typically broken out in the manner which I just mentioned, but we can get back to you on that, Senator.
That's fine. How do you determine family relationship there? As you've already mentioned before in your prior testimony, there are adults that are coming across the border carrying a child with them or bringing a child with them so they can say they're a family unit. How are you determining who is a family unit and who is not?
Well, thank you, Senator. We're using every resource at our disposal. So not only our biographic and biometric databases, our interviews with the actual families themselves. If they are not carrying documents, we will reach into the consulate contacts that we have also, our colleagues throughout the law enforcement community. And again, leaning on the behavioral analysis and skills of our frontline agents and officers to make those determinations, ultimately, whether or not the family unit is in fact, or the parentage that's being claimed is in fact a valid one.
Do you have to resort to DNA testing at times to be able to determine that?
We don't do DNA testing at the border, sir.
So is there an additional penalty for an adult bringing a child with them, claiming to be a family member, but then you determine this is not actually a family member, this is them trying to be released in the country? Is there any additional consequence for that individual adult?
Well, typically, yes, Senator. So if we find that fraudulent claim be made, then we will refer that individual for potential prosecution, as well as, of course, take great care, as I mentioned earlier, of the safety and well-being of the child.
Because at that point, that child's being trafficked or that child's being used by the adult for whatever purpose to be able to try to get across the border early. Then we've got to actually try to find their family.
And those are the determinations that, again, uniquely case by case that were subsequently made and that are investigated. So whether or not it was a trafficking organization that was simply trying, to gain profit, as many of them will do, in marketing themselves to these migrants to take this very dangerous journey, or whether or not it is a serious and or more, alarming case at times of human trafficking. Those are subsequently then investigated both by ourselves and our colleagues at ICE to make those determinations. And then, again, as you asked, determine what end state and or disposition we will collectively have with the individual that's found to be, perpetuating these illicit acts.
Okay, thank you, and thank you for the ongoing work that y'all are doing all the time in that for those kids and those families. We talked about push and pull factors some today. Over the last 3 years, the United States Congress has allocated about $650 million in economic assistance for the Northern Triangle, for economic investment there to be able to increase jobs, for anti-corruption efforts, for criminal justice efforts to try to help reduce the crime rate. The murder rate has dropped some in the Northern Triangle. There has been some economic development that's there, but we have made tremendous investments of around $650 million a year each year into the Northern Triangle to be able to help them have a more stable environment that people aren't having to flee. At the same time, I'm concerned about the pull factor here because most of the children that are coming as unaccompanied minors and many of the individuals that are coming as family units are coming because there's a family member already here. Is it our policy currently, if there is a family member already present in the United States, even if they're not legally present in the United States, that unaccompanied minor can be placed with someone not legally present in the United States?
Those determinations are made by HHS, but I can tell you that the policy of that agency is the immigration status of the sponsor is not relevant to their determination as to whether or not a child can be placed in that household, which from our data that we've seen just recently, you're looking at close to 80% of the people that are sponsors or household members within these residences are illegally here in the country.
So that has not always been so. If you go back 15, 20 years ago, if someone came into the country illegally as a child, they were not placed in a home of someone who was also didn't have legal status in the United States. The sponsor had to be someone who had legal status or was a United States citizen if you go back in time. So my question is that a reasonable standard to be able to have and to be able to go back to is that we do not have sponsors that do not have legal presence in the United States?
You're getting me way out of my lane here because that's really an HHS decision. I wouldn't want to weigh in on to how they manage their resources.
Mr. Perez, what effect do you think that would have on the pull factor?
Thank you, Senator. I think, from CBP's perspective, pecking away at any of the potential pull factors that we're seeing that create this spike of movement, one that is, again, wrought with danger, wrought with exploitation, wrought with abuse and abandonment at times, is something that we're interested in seeing. Again, as Mr. Albin suggests, it really is HHS to answer, in depth the question that you're posing. But I think a very important point that I'd like to make from the CBP perspective is that in my opening I talked of the complexity that oftentimes I think gets overlooked of what it is being done at the front line of the border. The national security mission, the trade and travel mission, the drug interdiction mission, the trade enforcement mission, all critical missions that are taxed, if you will, by the surge in migrants.
Mr. Chairman, there seems to be some very obvious things that we can do. Senator McCaskill has brought up again the judges. You've brought up the judges and expanding the number of judges. I think it's something that we really need to continue to be able to press in on and to say we've got to have a faster adjudication and due process than 2 years, 2.5 years. One of the issues that we've got to address is this issue about sponsorship. We tend to, quote unquote, lose children when they go and are placed in a home with someone who's already not legally present, who's been living under the radar for years, and then we're surprised when they both disappear. That shouldn't surprise us. That is something, if we're going to take care of children, we've got to find a way to be able to take care of children and not put them in the home of someone who's not legally present here. But that also discourages people from saying, you're 14 years old, your dad is already in the United States working, it's time for you to go join them, and encourage that activity and that connection point. And the last thing we haven't talked about is the licensing of the facilities. And I'd like to be able to do some follow-up on that because the Flores Agreement requires a licensed facility, but that has been quite a barrier to actually get licensed facilities from a state for a family facility, and I think it's created an artificial barrier for us. And I'd like to be able to follow up on those in the days ahead.
I appreciate that. And again, I think there are some pretty common sense things that we can all agree on to start solving this problem, but we do need to agree on the data. You talked about children. 70% of the unaccompanied children are male, 70% are 15 or older. They're not 3 years old. The other thing, Mr. President, I want to talk to you because we've been tracking this very carefully, month by month for a number of years, family apprehensions between the borders. So again, this is our blue chart here, and you responded to Senator Langford. There was 130,000 individuals between the borders and at the ports of entry through August. We've got 90,000 family units between the borders. So again, I want you to check, because again, we've been tracking this very carefully. I think potentially, my guess is 130,000 family units. Average number in a family is 2.1 is what we have from DHS. So if you kind of check that, because again, we need to make sure that we're actually talking about the same things, we're using the same figures. Okay, so maybe you can have something behind in terms of what you just told Senator Langford. Senator Hassan.
Thank you, Mr. Chair, and thank you and Ranking Member McCaskill for holding this hearing. Thank you to all of the witnesses for being here today, and to the members of law enforcement represented here today. I want to thank you for your work. I had the opportunity to visit some of the ports of entry that CBP runs last spring to look at your efforts around drug interdiction, and we are very grateful for the hard work and risks that your officers take. I wanted to get down to what I think Senator Peters began to get to, which is what this hearing really is all about. What this hearing comes down to for me is whether the federal government should be keeping children in detention indefinitely while waiting for a judge to review their case. We are talking about the indefinite detention of children. That's frankly not who we are as a country, and it's not what the United States should become. Senator Peters referenced the American Academy of Pediatrics. It strongly opposes long-term detention of children. A March 2017 report from the Academy notes that such detention, and this is a quote, can cause psychological trauma and induce long-term mental health risks for children, close quote. The report goes on to say that detaining children can lead to physical and emotional symptoms such as post-traumatic stress disorder, suicidal ideation, behavioral problems, and difficulty functioning in school. I'm going to ask both Mr. Albans and Mr. Perez just to clarify your answer to Senator Peters. Are you aware of that report from the American Academy of Pediatrics? First, Mr. Albans.
If I could just clarify, we don't have indefinite detention.
My question is, are you aware of that report from the American Academy of Pediatrics?
I think I've seen media reports on that report.
Okay. And Mr. Perez.
I am not, Senator. The age of someone else in the agency may be, but I am not.
All right, thank you. We'll make sure that you get copies of it. In addition to the American Academy of Pediatrics, 2 physicians who work for the Department of Homeland Security came forward in July as whistleblowers. They had both visited detention centers housing children that provided an appalling lack of care, including finding, and this is a quote, an infant with bleed of the brain that went undiagnosed for 5 days. Those same physicians stated publicly that detaining children risks permanent psychological harm, placing children at risk of post-traumatic stress and depression later in life. So again, Mr. Albans, have you seen these statements from these DHS whistleblowers?
I don't believe I have, no.
And Mr. Perez?
I have not, Senator.
Beyond the pediatricians and the whistleblowers, Immigration and Customs Enforcement itself set up an advisory committee of subject matter experts to review family detention. And here's what the agency's own advisory committee found. It said that DHS should, quote, discontinue the general use of family detention, and that in cases where detention was absolutely necessary, families should be detained for, quote, the shortest amount of time possible. Now, given that it is DHS's own findings, I'm going to assume that you guys are familiar with that. Mr. Albans, given these findings from the American Academy of Pediatrics, DHS whistleblowers, and your agency's own advisory committee, why does Immigration and Customs Enforcement continue to support modifying the Florence Agreement to allow for the indefinite detention of children?
Okay, as I previously stated, we do not have indefinite detention. The Supreme Court has ruled on that.
But you are recommending the modification or overruling of the Flores decision, which would allow the indefinite detention of children.
Again, there is no indefinite detention of children. People are detained and just...
Right now there isn't because the Flores
But again, our
agreement.
if you let me answer, please.
Excuse me, but I have limited amount of time here. And what I'm trying to get at is you are all here saying, or 3 of the 4 of you are here saying, that you want us to allow the federal government to do something that the Flores Agreement does not currently allow. So I understand your current position. But why are you here recommending a set of changes that would allow the indefinite detention of children?
Okay. What we are doing in this regulation is implementing the process as contemplated by the court in its ruling, which was requiring the licensing of that children could be held in licensed facilities. We have been unable to get state licensure in most places. What we have requested and are proposing underneath this regulation is to establish a federal licensing scheme which will be similar and mirror to what we currently utilize in our standards that would enable us to have the authority to hold these individuals. There's no one is arguing there's not a humanitarian crisis. I think the numbers show it.
Mr.
Humanitarian
Albans,
crisis also.
I have
people
limited
being
time,
smuggled
so
across
I'm
the
going to
border.
ask you to stop for a second, because what I'm concerned about is your own agency says that there shouldn't be indefinite or long-term detention of children, that it should be as short as possible. And instead of going towards the remedies that could help us, some that Senator McCaskill suggested, some that you've heard from other members of the panel suggested, instead of going towards those remedies to deal with the immigration surge, you are instead recommending something that experts in child development and welfare ask you not to do in your own people. Now, I want to go on to Mr. Perez. Why does CBP continue to support indefinite detention of children?
Thank you, Senator. I will respectfully just explain that from CBP's perspective, the modification of the Flores Agreement is more so a deterrence and or the ability to help deter a myriad of pull factors that exist throughout the entire immigration continuum, if you will, by creating a legal framework that does not create disparity in the treatment of single adults and or family units.
Thank you. Because, again, I'm running out of time, I will follow up with you further. First, I'm going to suggest our office will get to you the various reports about the impact of on children of long-term, any kind of detention. Earlier this year, we were faced with a humanitarian crisis that President Trump created on our southern border. The administration decided that the best course of action was to forcibly separate thousands of children from their parents. That was an affront to American values, and Americans all across this country from all walks of life objected to it. And now the proposed solution that I'm hearing today is to keep children in detention indefinitely. We know that that is harmful to these children, just as forcibly separating children from their parents is. Pediatricians are telling us, DHS whistleblowers are telling us, that based on the conditions they're seeing on the ground, that this is wrong and bad for children, and the Immigration and Customs Enforcement's own advisory committee is telling us that. Not to mention that any parent can tell you how harmful detention and separation is to children. I won't support this committee moving forward with this legislation that allows the federal government to indefinitely detain children. I encourage my fellow members of this committee and fellow members of the Senate to do that. We have heard lots of suggestions of important and practical ways to deal with the backlog and to make sure people come forward not only for their first hearing, but also for all subsequent hearings in the immigration process. But it is absolutely unacceptable to detain children and to have the United States of America, the strongest, best country in the world, treat children this way because we don't want to do other things that are more difficult. That is not who we are. We are stronger than that, we are better than that, and we are far more capable than that. Thank you, Mr. Chair.
Thanks, Senator Hassan. I do want to give Mr. Albans a chance to talk about indefinite. But from my standpoint, I don't want to see indefinite detention. I don't think that's what we're asking. What we're saying is, give ICE the ability to detain longer than 20 days so that they don't have to make gut-wrenching decision. Is that the father, or is that the sex trafficker? Is that his daughter? Is that the victim? Because they can't determine parentage in 20 days. So the whole point would be to provide the resources so that we can adjudicate those claims as quickly as possible. Those family units that seem eligible for asylum, that's where you do some kind of alternate to detention. Those that really have no valid claim, that looks pretty much like they're going to be removed, remove them as quickly as possible. So again, I'm certainly not supporting indefinite detention. I don't think that's really what ICE is trying to do with this administration.
Mr. Chair, respectfully, without deadlines, without caps, without ceilings, detentions can become indefinite. We are already seeing and hearing from these very witnesses how long it takes for those who aren't in detention to be heard because we can't get around to hiring immigration judges or trial attorneys fast enough, or paying them enough, or resourcing it enough. And as soon as we license detention facilities that allow children to be detained for longer, they are going to be, by definition, in indefinite detention.
So again, some limits on that are something I'm more than happy to discuss with you. Okay, I think it'd probably be a reasonable proposal. Senator Heidkamp.
Thank you, Mr. Chairman. I think the common interest for everyone here is, number one, children. So if we can just kind of take away all of the layers and say we're going to focus on keeping children safe. These children had no choice on whether they were going to come to the border. They were brought by their parents, and now we have a situation at our border where people have legally applied for asylum, and we're going to have to decide what's going to happen. Now, what I will tell you is this movement towards more permanent detention, if we're going to call that, of minors, what would recommend us that we do that when I look at our current record of what's happening to kids in detention? So let's just for a minute say that we're going to basically allow extended detention of children. I have a couple questions. I raised this issue last time we were all here on the Permanent Subcommittee on Investigations, the issue of sex abuse, sexual assault, and rape of immigrant children who were detained in facilities under the contract of the federal government. Where are we at with investigating those? Where are we at of reviewing our contractors? So we have this problem already that's been well reported and well documented. Now we're going to put more children in harm's way? So where are we at with these I think maybe for the Department of Justice, we'll start with you. This problem started with you. I think we all know that. Started when you decided you were going to separate kids at the border. Now we have all these kids that we don't know what to do with, and we can't find their parents, or their parents may have left without them. And they're in facilities where they're being abused, sexually assaulted. Whose responsibility is to fix that problem and investigate it and prosecute it?
Well, Senator, if I may start, I'm not sure I agree with the premise that the problem started with the Department of Justice. The Department of Justice issued a memo that was a memo involving prosecutorial exercise. So what the department was doing was stating that the federal prosecutors along the southwest border would be prosecuting and would be accepting referrals for prosecution from the Department of Homeland Security matters involving unlawful entry under 1325A of the Act, which
I'm more interested in what you're doing to investigate instances of sexual assault and otherwise abuse of children in our custody.
Senator, I would defer to the Department of Homeland Security and Health and Human Services. I can't speak to what the Department of Justice is doing on, especially if it involves ongoing investigations.
Do you think it's a federal crime if they're in a federal facility, federal contract facility?
Senator, again, I wouldn't be able to.
You should figure that out. You know, I think it would be appropriate to at least ask the question of who has jurisdiction. So maybe we'll turn to Department of Homeland Security. Who's investigating these claims, and can we expect indictments and prosecutions anytime soon?
I'm not aware of any allegations regarding sexual assault in any of ICE's FRCs.
Okay. You know, maybe we're looking at federal government facilities. Mr. Perez, can you help me out here?
Thank you, Senator. Our Office of Professional Responsibility is looking into the allegations, some allegations, relatively small number of allegations when you consider the nearly 500,000, again, annually, inadmissibles that are temporarily detained in facilities that are meant to only hold people no more than 3 days. Nevertheless, comply with the Prison Rape Elimination Act standards, comply with our own transport, escort, and detention standards. And as I mentioned earlier, quite typically, not only designed for short-term detention, but our frontline agents and officers go over and above to make sure that we are complying with all those standards. And we are vigorously looking into the allegations made, and we're glad to share with those outcomes once those investigations are.
And out of fairness, we're talking about what we're going to do to try and resolve this issue of separation of kids, which, you know, it's the catch-22. I will acknowledge what the chairman is saying. We want these kids to be kept with their parents. The American public wants appropriate reaction to people who are seeking asylum and not letting people, you know, get a free pass in because they show up with a kid. I get that. I get that we have a challenge here. But a common purpose should be preventing children in our custody from being abused either physically or sexually. And the person who's not at the podium today is HHS. Right? But yet they're the entity and they're the organization who's going to be responsible for some kind of extended detention of children and families. So we're caught in this spot where we're trying to figure out how we can best enforce our law, and we all agree that that should happen, and how we can protect kids. And it's always the kids that seem to take a back seat here. And I don't think that's right, and I don't think it reflects American values. I don't think it reflects the values of who we are. I don't care if you're a Democrat or Republican. No one thinks kids should be put in harm's way. But yet the fact that the Department of Justice doesn't know if that's a federal crime, if it occurs at a federally contracted facility, that's disturbing to me.
Senator, what I would say is if there is an investigation and there are allegations and that's referred to the appropriate U.S. Attorney's Office for prosecution, then based on those facts, the U.S. Attorney's Office will make the determination whether prosecution is appropriate.
Do you think it's appropriate to investigate contractors where this has been systematically revealed and discussed and reported?
I would, again, if Department of Homeland Security, if CBP is reviewing this through their professional responsibility component, certainly if they bring the Justice Department in, then we can.
I'm out of time, but I will tell you this. Until someone tells me how they are going to be better regulated and how we're going to get these facilities into compliance so that children are not abused, either sexually or physically, it's going to be really hard for us to expand any kind of detention jurisdiction. And so it's really important for me to understand how we are going to create a systemic system of protection of children, whether they're detained for 2 days or 3 days in an ICE facility, whether they are, you know, basically part of the apprehension process, or whether they're part of a longer-term detention I call it foster care system that the federal government through HHS is advancing. And these are not partisan questions. These are questions we need an answer to before we move on any additional scoping of detention. Thank you, Mr. Chair.
Yes, Senator Heidenkamp. Senator Jones is yielded to Senator Daines. Senator Daines.
I want to thank Senator Jones, too, for yielding. Thanks. Thank you, Mr. Chairman. And I want to thank the witnesses for coming here today for the very important work that you do for our nation. As we know, the reinterpretation of the Flores Settlement Agreement is at the crux of this catch-and-release policy for apprehended families. Flores presents a significant hurdle to the enforcement of our immigration laws. We need a solution that secures our border, upholds the rule of law, and accomplishes these goals without separating children from their parents as a default policy. And the administration has made it clear that Congress must act, and I heartily agree. I'm a father of 4, raised 4 children. I understand the importance of keeping families together. I also understand that the rule of law is a fundamental part of the foundation of our nation, and it also needs to be protected. I helped introduce 2 bills that address family separation at the border and to offer a fix to Flores. That's the Keep Families Together and Enforce the Law Act, as well as the Protect Kids and Parents Act. Both of these bills would require families to remain together while the adults who illegally cross the border face legal action. Furthermore, these bills would authorize additional immigration judges and provide mandatory standards of care for family residential centers to ensure suitable living accommodations. Mr. Albans, you listed some specific legislative changes that are needed to close the loopholes in our immigration system. How would fixing Flores better allow ICE and law enforcement to do their job?
Unfortunately, I'm limited to what I could speak based on the fact that the rule is out there right now for public comment. So I'm limited as to what I can say with regard to the rule and kind of have to limit my answers. I can tell you from an enforcement perspective, the transnational smuggling organizations that are bringing these people to the country are very good at messaging to the individuals in the Northern Triangle and these other countries that if they come to the United States as a family unit, that they will be processed quickly and released, and they never need to appear for court. They never have any repercussions for what they have, and no one's going to be out there looking for them and finding them. That is why you have a continual surge of individuals coming to the border. When we, in 2014, created family detention, we saw a marked drop of almost 40%, I believe, in the number of apprehensions by CBP because of the fact that there were consequences to that illegal activity that these individuals were engaging in.
Just yesterday, the Senate passed legislation that will help combat the meth and opioid crisis in our country. Before the vote, I went to the Senate floor and I spoke about the devastating effects of meth and opioid use is having in Montana. We've seen drastic increases in meth and heroin use in Montana. In fact, from 2011 to 2017, there was a 415% increase in meth and a 1,234% increase in heroin found in controlled substance cases in the state. Furthermore, we've seen a 375% increase in meth found in post-mortem cases during the same time frame. Keep in mind, Montana is a long ways away from our southern border, but those drugs are coming through our southern border. Mr. Perez, as you point out in your testimony, the increasing numbers of individuals held in CBP facilities divert CBP resources from addressing a number of serious threats to our nation, including transnational criminal organizations and dangerous narcotics that are wreaking havoc in places like Montana. CBP has a vast mission. I understand it's often a balancing act with limited resources. My question is, how do we ensure that stopping the flow of illicit drugs at the border remains a top priority, and how do we better prevent these drugs from reaching communities in places like Montana?
Thank you, Senator. First, I'd like to absolutely tell you that it is, for CBP, a absolute top priority amongst the complex mission set that we have. That is to stop this terrible scourge of not only narcotics in general, illegal narcotics being trafficked by these transnational criminal organizations across our border, but in particular, the two you mentioned, the ongoing synthetic opioid crisis, that with fentanyl and other synthetic drugs like meth. This is, again, an ongoing daily challenge, one that we bring all our resources to bear, again, all the training and expertise of our agents and officers, the technology that we have at our disposal, our canines, and our advanced information, our targeting techniques, again, working alongside our investigative arm in ICE to dismantle as well, subsequent to seizures, these transnational criminal organizations to the best degree we possibly can. That is why I circle back with this particular topic, CBP's particular interest in what it can possibly and probably do with respect to eliminating a pull factor. We just as soon see those numbers of illegal migrants drop. People, again, not choosing to take a long, arduous, and sometimes very dangerous journey that also exposes them, again, to being exploited by human trafficking organizations, by other criminal elements, and frankly, again, criminal organizations that have only profit in mind, and then these folks end up becoming victims themselves, even more so than where it is that they're fleeing from. And so that is why it is so critical for us that these loopholes be addressed in order to bring those numbers down as far as what is actually arriving at and or between our ports of entry.
I think it's important because it's a zero-sum game here. Every moment you're spending here addressing this issue of the illegal crossings is time spent that could be used to stop the flow of illegal drugs.
Thank you, Senator. And as I mentioned earlier, legitimate trade and travel, national security concerns, pests that threaten our agriculture, our economy. Those are all amongst the myriad of missions that CBP has, including dealing with migrants, which we do as humanely and as caringly as we possibly can, particularly when children are involved. So it is a delicate balance that we strike every day.
I got a question, Mr. Albans. Thank you, and thanks for your work to secure our borders. Mr. Albans, I want to know if alternatives to detention work.
Alternatives to detention are a fairly effective tool at getting people to appear at some or all of their immigration court hearings. It's a woefully ineffective tool at actually allowing ICE to effectuate a removal order issued by an immigration judge.
Like ankle monitors, for example, effective or not?
Again, getting people to a hearing, they're fairly effective. Actually enforcing a judge's removal order, they're woefully ineffective.
Last question. Has the implementation of the MOA helped ICE remove criminal aliens?
Are you talking the MOA with regard to HHS and the fingerprinting of sponsors?
Yes.
Yeah. We've arrested 41 individuals thus far that we've identified pursuant to that MOA. Our data that we've received thus far indicates that close to 80% of the individuals that are either sponsors or household members of sponsors are here in the country illegally, and a large chunk of those are criminal aliens. So we will continue to pursue those individuals.
Thank you.
Senator Jones.
Thank you, Mr. Chairman, and thank you to all of our witnesses for appearing here today on this really important topic. My question, I want to talk a little bit about procedure to Mr. Albans and Mr. Edlow. Are you familiar with the 2016 study that the ABA did that said immigrants with counsel are 5 times more likely to win their cases than those without counsel? Are you familiar with that, Mr. Albans?
I may have seen some media reporting on that, but I can't say I'm intimately familiar with the report.
Mr. Edlow, are you familiar with it?
I've seen some reporting on several studies of that nature. I can't speak to that specific one.
Well, it seems to be important because if that study, and I have no reason to doubt that study, that immigrants that have counsel are 5 times more likely to win their cases, I think it's a testament to who is crossing the border and why. And we may be sending folks and deporting folks that have legitimate cases simply because they don't have access to counsel. So my question for both of you is the Department of Justice and is Homeland Security doing anything to try, are you taking into account in your processes the ability of folks to be able to get counsel? Because right now there is no constitutional right to counsel. They either have to get a pro bono counsel or try to get retained counsel, which is difficult to do. So is the ability to get counsel come into any factor in your considerations?
Thank you. Yes, actually, we have a very extensive legal orientation program that we work with many non-governmental organizations to provide legal counseling and pro bono counseling to our detainees. We actually have them on site in our family residential center in Dilley, Texas. They actually have office space, and one of the first things that the aliens that are booked into that facility experience is that legal orientation program. And they have private rooms to meet to go over their asylum claims before they speak with the asylum officers from CIS. Any individual that we arrest, families or otherwise, that we take into custody, we provide them with a list of free legal services and other opportunities for which to avail themselves.
All right, so if you get more lawyers, and I'll come to you real quick, but if you get more lawyers, you mentioned more lawyers to prosecute these cases, will you also try to expand the legal services ability for these immigrants that are coming in?
We'll certainly do whatever we can to provide individuals with legal orientation programs that they will avail themselves of.
All right. Mr. Edlow?
Thank you, Senator, for raising this topic. With regard to counsel, as I'm sure you're well aware, the immigration laws do not allow for government-funded counsels. Certainly, if Congress wishes to change the law, Congress is free to do so, but certainly at this stage, the government cannot provide counsel. The role of the immigration judge during the immigration court proceedings is to ensure a fair hearing for both sides. And oftentimes, that means that the alien is unrepresented. The judge has to step in and ensure that the alien is getting their entire claim out.
But that also bogs down the process. I mean, my experience is that in court proceedings of almost 40 years of practice now, the people that are represented by counsel, the proceedings move in a better pace and much more efficiently. Wouldn't you agree with that?
I would, but I would also note that if you've got to make sure it's an immigration lawyer that's coming to the proceedings on behalf of the alien, because a lot of times when pro bono counsel come in, there's a learning curve at that point that they need to figure out. But what I'm saying though is, in these instances, first of all, the judges give, when necessary, continuances to allow respondents to seek counsel. That's both detained and non-detained get time to seek counsel, especially non-detained get a significant period of time. Depending on the city where the court is, it could be several months. But ultimately, if the judge decides that the case has to go forward with the respondent unrepresented, there is painstaking process that is taken to ensure that alien gets a fair hearing and that those claims are fleshed out to the degree that they need to be.
Well, wouldn't you agree, though, that someone that is being detained has a harder time trying to retain counsel than someone who is not detained? And so is your proposed rules that we're talking about now, does it take into account the ability to get counsel?
Well, those are two separate questions. Let me take the second one first.
Okay.
Just so you're aware, the Department of Justice is not a party to the proposed rule.
Right.
So I can't comment on those rules, especially as we're in the middle of the notice and comment period. In terms of the attorneys coming into the courtroom, though, there are a significant number of organizations that regularly go to these detained facilities to make themselves available to detained respondents. That may include themselves representing these respondents. It may also be that they put these respondents in touch with other available pro bono attorneys. So there is, frankly,
there's a process in place.
There is a process in place. I think in a lot of cases it may be easier for a detained individual to meet with a pro bono attorney or meet with a legal organization that is looking to provide pro bono services than a non-detained alien.
All right. Well, I would encourage all parties to try to do what they can to ensure a swift ability to get counsel, because I think it will speed up the process. It will help the process, and particularly consider doing more to get these children advocates or guardian ad litem throughout our court system. No matter if a child is injured or whether it's a part of an adoption proceeding, they always have guardian ad litems to protect their interests, which I also think would help protect their safety. The last thing in the remaining time, Mr. Edlow, I'd like to talk about the filing system that you guys have. Back in over 30 years ago, the federal courts went to electronic filing. In 2001, EOR also decided that they would go back they would implement an electronic filing system. But as of today, it's still not out there. We're still dealing in the dark ages like I do with paper. I have books instead of my iPad sitting here. But look, I've been practicing law a long time, and I know how efficient it can run when you have an electronic filing system. What's going on? Why the delay in what every court in America is doing these days to speed their process and make it more efficient?
Senator, thank you for your question. You know, I can't speak to what previous administrations did or did not do, what action they were able to take to move this along. I can tell you from personal experience practicing in immigration court for many years, it would have been very helpful to have an electronic filing system. And I can also tell you that EOR is working very hard to get a pilot program out there and to figure out, get the kinks worked out so that we can do a nationwide rollout.
Have you got any kind of timeline on that?
Senator, I would get back to you on that. I would want to speak to the folks who are handling it at EOR to make sure that I get you the right information.
Great. Well, please do for that. Thank you very much, Mr. Chairman.
Senator Harris.
Thank you. And Senator Jones, I actually have a piece of legislation, the Access to Counsel Act. I couldn't agree with you more. These folks should not be denied access to counsel when they arrive. Mr. Albence, to follow up on questions you've been previously asked by my colleagues regarding the position of medical experts, including the American Pediatrics Association and the American Medical Association, you told us in July, I believe, quote, with regard to the family residential centers, I think the best way to describe them is to be more like a summer camp. When pressed on this statement, you said that you, quote, were very comfortable with the treatment of the immigrants at these centers. Do you stand by that statement?
Absolutely, I do. I just
You
came
believe
back-
they're like summer camps?
I believe the standards under which they are kept are very safe. They're humane.
Have you ever sent, do you have children or do you know children that have attended summer camp? Would you send your children to one of these detention centers?
Again, that question's not applicable. What I can tell you is that I went to a CODEL there just 3 weeks ago with Senator Boozman and Senator Capito, and what we saw there were children receiving excellent medical care. We saw children playing in the gymnasium. We saw families sitting at computers in a library that was well-stocked. We saw a cafeteria that was spotless with unlimited amounts of food with regard to when they eat. They live in dormitory settings with televisions, Xboxes, and a host of other recreational opportunities.
But you can understand the concern to suggest it's like a summer camp would suggest that a parent would voluntarily send their child to a place like that to have a good time for the summer.
Well, you're missing, but the point is,
Excuse me,
the parent
I'm not
made the
done.
illegal entry. The parent put themselves in this position. They made the illegal entry into the country. That is why they are there.
You're here because this is an oversight committee hearing. So I'm asking you specific questions to gauge your ability to actually conduct oversight over the operations of your agency. Moving on. Mr. Perez, I'm sure you're aware of the great public outrage at seeing images of young children at CBP custody in large metal detention cages. They apparently have been given Mylar blankets and camping pads to sleep on concrete floors for multiple nights. Since the President signed the executive order on June 20th, 2018 regarding family separation, have any families been separated at the border, and if so, how many?
Thank you, Senator. We are not separating families at the border, at or between the ports of entry. As I mentioned earlier, the temporary detainment facilities that are run at the ports of entry, run by the Border Patrol, are meant for short-term holding. And the men and women on the front line of CBP go above and beyond not only the imposed standards on maintaining the sanitary, the healthy conditions, and the care of those in our custody, family units, and adults and children.
So I just want to be clear that we're thinking the same thing. I'm asking, are you saying then that no families have actually been separated since the executive order was signed on June 20th?
The only instances in where families would be separated is if there is an element of false parentage, a criminal situation with the actual adult and the child, a health concern or a safety concern for that child.
Do you know how many such cases there have been since June 20th of 2018?
We could get back to you on that, Senator, but again, those would be the only circumstances, again, with the safety and well-being of the child first and foremost on our mind, where a family would be separated.
So other than that, there are no families that have been separated since the signing of that executive order?
Yes, ma'am.
And then, Mr. Albence, I've asked repeatedly for information on the number and the status of any cases, if they exist, where your agency has referred an adult who accompanied a child to prosecution for trafficking. And I've still not received that information. So in your briefing, I'm sure you're prepared to answer the question because I ask it every time. How many cases has your agency referred to the Department of Justice for prosecution or even investigation of trafficking, since that appears to be the basis for some of your policies, a concern that trafficking exists?
So thus far, Homeland Security Investigations within ICE has initiated 778 human trafficking investigations, has made 1,410 human trafficking arrests, criminal arrests, has obtained 759 indictments, and 425 convictions.
Since what date is that?
That's this fiscal year up through August 31st.
And are those cases where the concern was that an adult who was accompanying a child, because that's the specific question, adults who are accompanying a child who arrive at our border, how many of those cases have been referred for trafficking prosecution?
We would have to get back with you on that. We'd have to go look in our records to see.
Okay,
But
when
certainly glad
can
to
I
do
expect to get that information?
I wouldn't think it'd take more than a couple of weeks.
Okay, so by the end of next week, is that doable?
I'll go back and talk to, I'm not quite familiar with the ICM and how searchable it is, but once I find out, we'll certainly let you know.
Okay, I appreciate that. And also, and I don't know if it's either Mr. Albence or Mr. Perez, whichever, or if both of you can answer this question, but I'm assuming that you're both aware that there are affidavits that have been filed this summer alleging that children faced limited access to food and water and experienced spoiled food, freezing temperatures, and verbal and physical assault in CBP custody. Mr. Perez, are you aware of that?
Thank you, Senator. We mentioned earlier our Office of Professional Responsibility alongside DHS's Office of Inspector General have been investigating any and all of those allegations of misconduct. We take those investigations and those allegations very seriously, as we do with any other allegation of misconduct by either contractors or employees. Nevertheless, very confident that given the amount of intake and allegations and cases that there are versus the nearly, again, almost 500,000 admissibles that we are detaining and encountering, that the instances with which this is occurring are relatively modest, and that, again, our frontline agents and officers are doing the best they can to take care of these folks.
Thank you. I have
over and
just a
above.
few seconds left. I've asked on both April 22nd and May 15th DHS officials about CBP employee training as it pertains to the handling of children, as well as training that pertains to the handling of the youngest children in your detention facilities, and I've not received a response. Can one of you tell me where that information is, or if it exists at all? And that is what you're doing to train your employees who are having direct contact with children and their parents on how they should be approached in the least traumatic manner.
Absolutely, Senator. We can get back to you. I will make sure that we do respond to you with the actual laydown of the training that we provide, but I can tell you very briefly that our agents and officers annually are required to take training both with respect to potential human trafficking concerns, exploitation of children, and or the care and custody of the children in our temporary detention facilities through our transportation escort and detention standards.
Thank you. And again, I'll note I asked for this information on April 26th and again on May 15th, so I'd appreciate your swift response. Thank you.
Senator Carper.
Thanks, Mr. Chairman. Welcome, one and all. I want to return to a subject that I've turned to many times on this committee, as my colleagues will affirm, and that is root causes. Root causes. And I've long been a proponent of common sense, comprehensive immigration reform to fix our broken immigration system. But it seems to me that a proposal to hold families indefinitely fails to address an incredibly important part of the equation, that is the push factor that leads so many to seek safe havens here in the United States. When I was privileged to serve as chairman and ranking member of this committee, I made any number of trips to Mexico, to Central America, to Honduras, Guatemala, and Salvador, in order to try to better understand the root causes of migration to the U.S., joined by a number of members of this panel, including our chairman and Senator Heitkamp. What I learned on those trips is that many people in those countries live in fear for their lives. Gang violence is, in too many instances, rampant. Government officials are too often unaccountable. And many people have no hope of, or little hope of, a better economic situation for themselves and their families. I think unless we work with our neighbors to the south, continue to work with our neighbors to the south, work more effectively with our neighbors to the south, to address the factors that lead so many to seek safe haven in the U.S., including lack of rule of law, unimaginable violence, the lack of economic opportunity. We're simply putting a Band-Aid on the problem. In its most recent budget request, the Trump administration asked for about $430 million to support the U.S. strategy for engagement in Central America. I think that's less than half of what was initially sought by the Obama administration. It's about almost a third less than this year's appropriation. This occurred despite the fact that some in the administration, including General Kelly and Commissioner McLeland, have argued for continued funding for this strategy. Thankfully, bipartisan Senate appropriators agreed on the importance of continued funding, and they restored President Trump's cuts. Parents and children facing sure death at home or likely death at home will continue to make this dangerous journey to our borders, despite nearly any inhumane policy this administration might, or other administrations might pursue. For all the witnesses, this question. Take a moment and react to that. Do you agree that any effective strategy to secure our border must address the root causes of migration? Let's just start with you, Ms. Gambler.
I think that seems reasonable, and certainly through GAO's work, as you've indicated, Senator, we found that there can be a mix of factors contributing to unaccompanied children leaving their countries and coming to the United States, to include both factors in their home countries as well as factors here.
Mm-hmm. Thank you. Mr. Edlow.
Thank you, Senator. Certainly, in terms of the root cause of the migration, you're going to see push and pull factors with what's going on here in this country. We saw that in 2015 when the Flores interpretation came out that included accompanied minors. We saw an increase in apprehensions of families along the border. I'm not saying that's the only reason that they were coming, but certainly that does help. Also, when there appears to be a consequence, there does appear to be a drop in those apprehension numbers too. We saw after President Trump's inauguration that there was a 40% decrease in apprehensions for a period of months. Certainly, there are so many varied push and pull factors that would have to be addressed, and I would just say that the department welcomes legislation to address those, to come up with a more equitable solution moving forward.
Thank you. Mr. Perez.
Thank you, Senator. I believe you mentioned the Commissioner's previous testimony. I can assure you that CBP, alongside our DHS colleagues, continue to invest and put forth a significant effort in working with our counterpart agencies throughout the hemisphere, particularly in Mexico and the Northern Triangle, the creation of vetted units, systems and information sharing, capacity building to the extent of even modernizing and helping them to modernize some of their trade functions to address the different push factors. So that does certainly remain a priority for CBP and something that we're going to continue to put forth an effort on. I would just echo my colleague's comment that you know, with it, for us, it is so critically important, given the entirety of this, as I like to call it, the immigration continuum, that it is an effort for the push and pull factors, which are many, that we ever so have, when we ever so have the opportunity to address some of those, to again prevent someone from ever embarking on what is oftentimes a very, very dangerous journey. That we would again welcome those discussions.
Thank you. Mr. Robbins, just be very brief in your response, if you would. So
I would just echo the sentiments of my colleagues. ICE has invested significant resources both on its Homeland Security investigations as well as enforcement and removal operations in the Central American and Mexican regions to help dissuade some of this travel. I will also say I think it is a humanitarian issue, and I think it's incumbent upon us to limit those pull factors that exist to stop people from making this dangerous journey. If individuals in those countries know that they're going to spend their life savings to try to get here and run that risk of going through cartels and smugglers and all sorts of horrific abuse that happens to these individuals on the trip, and that when they get to this country, if they have no lawful right to be here, that they will actually be ordered removed, and that removal order will be effectuated in a timely fashion, that humanitarian issue will decrease significantly because people will stop making the trip, as we have seen before.
I don't ask a lot of yes or no questions. I'm going to ask one now. And it's not a trick question. It's just yes or no. That'd be helpful. Would you all support a proposal that provides funding to address the root causes of migration from Central America, which includes ensuring that law enforcement there has the resources it needs to fight organized crime, drug cartels, and gangs? Mr. Albans?
Yes, sir.
Thank you. Mr. Perez?
Yes, Senator.
Yeah. Mr. Edlow?
Senator, I'm sorry, the department would have to take a look at the legislation and then make a determination whether it could be supported.
Thank you. Ms. Gamble, you care to take a gamble on that one?
Of course, funding decisions are within Congress's authority, but certainly we agree that there are factors in those Central American countries that are contributing to some of the migration.
All right. I'm out of time.
And we do have a vote called, so.
I understand. I have some more questions for the record. I've got to just say one thing in closing. We've been funding this Alliance for Prosperity now for, I think, maybe our third year. And the chairman's been down to these same places, sometimes with us together, other times on separate CODELs. I've watched with interest over the last 20 years what has happened in Colombia, a place that was where, 20 years ago you had a bunch of gunmen rounded up their Supreme Court and shot them all to death. And to go from that point in time to a country that's stable, not perfect, but economically strong and vibrant, and has actually made a success of themselves. We've helped them. And I always like to say it's just like Home Depot. You can do it, we can help. And that's what we've done with Colombia. And that's what we need to continue to do with Honduras, Guatemala, and Salvador. If we do, they can do it. But we need to help. Thank you.
Senator Carper, before you leave, just a couple points. If you can put my blue chart up there for my next question. We have traveled down there, and we've done a lot of hearings, and I think we would agree that it's our insatiable demand for drugs that gave rise to drug cartels and destroyed public institutions down there. We bear responsibility. But I want to ask Mr. Perez real quick. The exact same detention facilities that we were really on a nonpartisan, bipartisan basis praising in 2014 at the height of the UAC crisis, those are the exact same detention facilities that CBP is using to just handle, again, the continuing flow of unaccompanied children and family units, correct?
They are, Mr. Chairman.
Again, they're not designed to keep people in cages for an indefinite period. This is really, you're funneling people through these detention facilities where you delouse them, you provide some additional medical assessment, and try and move them out of there within about a 24-hour period, correct?
As best and as quickly and safely as we possibly can, and effectively, yes.
But again, I just want to make sure, because right now, 2014, we were praising, CBP's efforts. Now we're calling them cages, and they're exact same facilities. Real quick, that chart I think is pretty telling. The picture says an awful lot. And what it tells me is that detention did work. We had Secretary Chertoff in 2008 when he had the Brazilian crisis, where there were 88 apprehensions in 1992. In 2005, because of a number of reasons, there were 32,000. And then Secretary Chertoff really began a process of apprehending, detaining, and removing them back to Brazil. And a year later, there are less than 1,500. The Obama administration kind of recognized the same point. In 2014, we saw a surge in UACs as well as family units that began detaining, with the whole process of those that didn't qualify for asylum would be returned. That really, from my standpoint, it's pretty obvious that worked. I mean, anybody want to dispute that, or it'll just quick it on the line? Mr. Albans, do you believe that detention did serve as an effective deterrent?
I think detention coupled with removal and consequences to illegal activity serves as an effective deterrent. Detention in and of itself is...
And again, no, I am saying detention and removal. Okay, Mr. Perez?
I believe the data speaks for itself, Mr. Chairman, with respect to what it is that can possibly be realized when there is consequences that are delivered for illegal activity.
Mr. Edlow?
Senator, I would echo what my colleagues have already said. Certainly, when there is a consequence, we see immigration flows respond to that consequence.
Ms. Gambler.
We haven't specifically studied the issue to be able to make an assessment one way or the other.
Just as like a sentient human being, I mean, to kind of look at that, you figure something's going on there,
I
right?
would add more broadly, not just as it relates to families, but certainly, you know, Border Patrol and CBP have implemented programs to apply consequences to individuals who are apprehended crossing the border. And I think the intent of those consequences is in part to address what you're speaking to.
And Mr. Perez, you talked about the perception in Central America. It's way more than perception. It's a reality. The drug cartels, the human traffickers, the transnational criminal organizations are using these loopholes, right? They're talking about, whether it was, you know, back in 2012 about DACA, the permiso slips. They're using that, telling individuals from Central America, come on in America and you can stay, and by and large they stay, correct?
And that's why I followed up. Thank you, Mr. Chairman. That's why I followed up that with my comment about the perception being at times a reality, that the loopholes that exist by virtue of you know, judicial decisions and or legal loopholes in effect have had and made these perceptions an operational reality by not being able to deliver uniform consequence throughout the entirety of the immigration process.
Mr. Albence, did you basically concur with that fact that whether it's the Flores decision, whether it's the, you know, the human trafficking bill in 2008, these created a circumstance that is being used and being exploited by drug cartels and human traffickers, correct?
Certainly. Not only does our intelligence tell us that, the individuals that we interview, that CBP interviews, tell us that, but the numbers speak for themselves. Ms. Gambler, in your testimony you talked about that the administration had actually met its goals in terms of alternate alternatives to detention. That was set at 2,899 out of a population of approximately 40,000 in the program. I mean, that's 7%. It's not exactly a stretch goal, is it?
No, it's not. And those measures, that measure in particular was fairly new when we looked at the program. It had only been in place for about 2 years. I would also add that at least at the time that we were reviewing the Alternatives to Detention program, which was a few years ago, that was measuring removals, and it was counting whether or not aliens who had been in an Alternatives to Detention program at any point during the same fiscal year in which they were removed. I know that Mr. Albence was mentioning some more recent data, and if it would be helpful, GAO would be happy to take a look at that as well. I think there's some intricacies in terms of the data associated with the Alternatives to Detention program and its performance that might be helpful to the committee for us to provide information on if it's helpful.
I would say for preparation of this committee, or for this hearing, all the information I got, bottom line, we need a lot more information in terms of real data on alternatives to detention. Again, it sounds like a good idea, but I think there's some real problems with it that we need to flesh out here. And you know, these types of statistics where 99% show up to hearing, yeah, until they get a removal order, and then it doesn't really behoove them. I mean, it makes a lot of sense. Show up to a hearing, you just might get asylum, but the minute you find out you're not going to get asylum, you abscond. So those are just common sense human behavior. And of course, a very low-level goal. I mean, under promise, over deliver. That's good in business, but I think we need to point out that fact. Final point, the administration is undergoing a rulemaking procedure, and this is really a sales pitch to pass legislation that hopefully the courts wouldn't overrule. They would actually respect the fact that Congress has spoken. But to fix this, the administration is undergoing a rulemaking, which was contemplated in the Flores settlement, correct, Mr. Edlow?
Yes, Senator. Back in 2001, there was a stipulation agreed to and added into the Flores settlement agreement that specifically contemplated the agreement terminating within a certain period of time following promulgation of regulations.
So a couple of laws have been passed. When Congress passed those laws, they probably figured they were taking care of the Flores settlement. The courts haven't recognized those laws, basically. Correct?
That's correct. Specifically TVPRA, and had it said this is enacted to terminate the Flores settlement agreement, it probably would have at that point.
Okay. I guess my final point, and this is why I think Congress has to act, and I know you really can't answer this, but I'm going to ask you to anyway. What do you think the probability is that when the administration issues a rule on this, going through the process, the Administrative Procedures Act, that is going to be challenged in court and will not be able to put into effect. It'll basically have the same problem. The courts will overrule the rulemaking.
The department, I really can't comment.
And anybody want to comment that just from a common sense standpoint? I mean, I know my view on that. I think it's going to be extremely high probability that the courts will intervene and this rulemaking will never be put into effect.
Senator, I would just add that should the rule be challenged following the notice and comment period, and I'm fully confident that the Department of Homeland Security and Health and Human Services will respond to those comments that come out of this process. The department will stand ready to defend the challenges as they come forward.
But it'd be a whole lot cleaner and a whole lot more certain if Congress had acted and passed a law and fixed this particular problem, correct?
Certainly, legislation would be preferable.
Okay, that's all I was looking for. And again, I want to thank all of you for taking the time for your testimony, for answering our questions. I think this hearing has definitely been helpful. I think it's moved us forward as a committee. We still have information, and I'm looking forward to future cooperation so we can get all the facts, get all the information, so we can set an achievable goal, which I think this is a more than achievable goal, so we can design a solution on what I would call a nonpartisan basis. With that, the hearing record will remain open for 15 days until October 3rd, 5 p.m. for the submission of statements and questions for the record. This hearing is adjourned.
Hey, Rebecca. Matt Ellis, nice to meet you.
Good to meet you.
Take care.